Good morning, everyone, and welcome to this morning's Moorcrofts Employment Law Update webinar. My name is Lindsay Abbott, and I'm Employment Partner on the team, and I'm joined by my colleague, Leah Waller, who is an employment solicitor. We're delighted that you're joining us this morning for our legislation update, covering what's recently come into effect and what's due to come into effect later on this year and next year. And we have 6 or 7 of the most interesting cases that's just come through the courts to go through with you as well. At the end of the webinar, a short survey is going to pop up, which takes less than a minute to complete. So please do complete it. It's about some questions about you, what you thought of the webinar and it helps us to tailor our content to you in the future to see what you might be interested in. Plus, we will have time, hopefully, for a couple of questions at the end. So if you want to ask us anything, do type those questions into the Q&A box, and we'll try and pick those up at the end, or we'll come back to you on those at a later date. So without further ado, let's kick off with our legislation update this morning, starting with the Neonatal Care Leave and Pay Act 2023. So neonatal care leave is available for parents of babies born on or after the 6th of April this year and allows parents to take up to 12 weeks of leave, regardless of how long they've worked for their employer. So it's a day one right. And parents are entitled to take this leave if their baby requires neonatal care within 28 days of birth for a continuous period of 7 days or longer. And the requirements for eligibility to take this leave is that the baby must be born on or after the 6th of April. The employee must be one of the baby's parents or intended parents in the case of surrogacy, or partner to the baby's mum. And the leave must be taken within 68 weeks of the baby's birth or placement for adoption. The right to take this leave is in addition to existing parental leave rights like maternity and paternity leave. And there are 2 tiers of leave that you can take. So tier 1 is for the period that the child is actually receiving neonatal care and for 1 week after that care has ended. And tier 2 is for periods of leave outside tier 1 and before the end of 68 weeks from birth. Tier 1 is most likely to be taken by fathers because they only get 2 weeks paternity leave. So, for example, if your baby goes into neonatal care as soon as they're born for 4 weeks and you're a dad on paternity leave, you would take 2 weeks of paternity leave and then 2 weeks of neonatal care under tier 1. And then you could reserve another 2 weeks for outside of that time. So you take that under tier 2. And tier 2 leave is most likely to be taken by mums, because of course, if you're a mum on maternity leave and your baby goes into neonatal care immediately for 4 weeks after they're born, you're still on mat leave. And what you can do is you can tack those 4 weeks neonatal care leave onto the end of your maternity leave. So you haven't missed out on those 4 weeks with your baby while your baby's been in care. And the right to receive statutory neonatal care pay requires 26 weeks of service and earnings on average of at least £125 a week. So that's similar to the eligibility requirements for what the same as maternity leave. And that will be paid at £187.18 a week, which is the same as other family related leave, or 90% of the employee's earnings, whichever is the lower. And the details of how to request the pay and how the leave and pay will operate is set out in the general regulations here. So now I'm going to be talking a little bit about the transfer of undertaking regulations, or the TUPE regulations. As I'm sure you're all already aware, this legislation protects employees' rights when part of the business is bought or sold, or transferred as we refer to it. And that obliges the employer to inform and consult with elected employee representatives of staff when buying and selling businesses. Now, there is a micro business exemption to consulting with employee representatives. So if a business has less than 10 employees, the employer can consult directly with the individual employees rather than having to elect employee reps when consulting about the transfer. So for anyone buying or selling a business after the 1st of July last year, some important changes came into effect. If there are no recognised trade unions or employee representatives, and either there are fewer than 50 employees or fewer than 10 employees transferring, regardless of the size of the employer, then employers can inform and consult directly with their employees. Otherwise, they have to arrange election with effective employees to vote for representatives. Extending this micro business exemption cuts out the onerous process of electing reps, and it gives the employer greater flexibility. Although that said, some employers might not want to take advantage of this. For example, if you have got up to 50 employees, it might just be easier to consult with reps as a go-between during these types of consultations. And if you get this wrong and you fail to inform and consult, then the employee can be awarded 13 weeks uncapped gross pay in an employment tribunal. So if you're buying and selling businesses and you meet these thresholds, you might want to take advantage of this exemption. So I'm moving on to talk about the Draft Equality, Race and Disability Bill. So this was announced in the King's Speech last year, and the government is launching consultation to seek views on its proposed measures. We've seen gender pay gap reporting for several years now, and what the government is doing is they're proposing to extend this to include ethnicity and disability for employers with 250 plus employees. So this bill will set out the right to equal pay for ethnic minorities and disabled people, making it easier for them to bring discrimination claims. And the framework of how to do this is going to be very similar to what's already in place for gender pay gap reporting. So there are 6 measures that will have to be reported: mean difference in average hourly pay, median difference in average hourly pay, pay quarters, so put employees into 4 equally sized groups and rank their highest to lowest hourly pay, and the mean and median difference in bonus pay, and also the percentage of employees receiving bonus pay for the relevant protected characteristics. The government's now seeking views on whether employers should be required to produce action plans to help identify the reasons for any gaps in pay here, and how to close those gaps and how to resolve those discrepancies. So if you have got more than 250 employees, or you work for an organisation that has more than 250 employees, you might want to start looking at your ethnicity and disability data now, perhaps doing a review of salaries so that you're ready for when this bill comes in. And you might also want to create action plans to resolve any discrepancies. So I'm moving on now to talk about the eagerly anticipated and highly discussed Employment Rights Bill. This is expected to be implemented sometime next year and proposes 28 employment law reforms. It also represents an overhaul, quite a large overhaul of the UK employment law legislation. And today we're not going to be looking at all 28 reforms. We're just focusing on some of those, starting with the 0 hours contracts and the right to guaranteed hours and reasonable notice of shift changes and cancellations, how that affects agency workers. And we'll be looking at collective consultation in redundancy changes, the newly proposed Fair Work Agency, and statutory sick pay for low earners. So the bill is making its way through Parliament. It's had its first and second readings in the House of Commons in October last year, and there were over 200 amendments proposed, and it's just had its second reading in the House of Lords last month. So 0 hours contracts. 0 hours contracts is a non-legal term. It's essentially a casual contract between an employer and a worker, where the employer doesn't guarantee hours but offers hours on an ad hoc as and when basis to the individual, and the individual chooses whether to accept or decline. If they accept the work, then that worker is entitled to employment law rights. Now, there has been some debate about whether or not these proposals mean an outright ban on 0 hours contract. I don't think that that's what it's going to mean in effect, which we'll go through as part of this presentation. But what it is proposing is the right to guaranteed hours for workers who are working regular hours over a set period of time, and also a reasonable notice of shift changes or calculations. So employers will need to calculate hours based on past working hours during a reference period. And from that, they must offer guaranteed hours. So guaranteed hours refers to a minimum number of hours that the employer will have to offer the worker based on their actual working hours over a specified reference period. Now, whilst the exact duration of the reference period isn't clear yet, it's supposed to assess the worker's typical working pattern so that guaranteed hours can be determined. This aims to provide a certain amount of job security for workers and an expectation of a certain amount of income, and it's aiming to end the one-sided flexibility that we're always hearing talked about in favour of employers that you get with these kind of contracts. So after a worker has been employed for a certain period of time, i.e. the reference period, the employer is obliged to offer a contract with guaranteed hours. Now, the bill does acknowledge that there are some sectors this might not work for. So say, for example, you've got uni students coming home from university in their holidays. It might not work for them, or other seasonal workers, or sometimes in the care sector as well. So there are provisions for the employer to enter into limited term contracts with individuals, but employers can't get out of the obligation to offer guaranteed hours simply by entering into a series of these limited terms contracts just to get out of that and doing a series of temp work or seasonal work with the same person over and over again. The worker has the right to decline that offer if they prefer more flexibility or a more flexible arrangement. But if the employee worker declines, the employer still has to keep offering a guaranteed hours contract after each subsequent reference period. Now, in terms of agency workers and how that affects agency workers, it will be the end user that has to offer these guaranteed hours. Presumably, this is because the end user is closer to the detail of what work that person is actually doing for them. But in terms of reasonable notice of shift changes and calculations, that's going to be the responsibility of both the agency and the end user. And that's going to be set out in secondary legislation to come. So your business can prepare for this change if you've got anyone on a casual contract by reviewing your existing employment agreements with those people and how you manage them, and forward plan your needs to assess how much this is going to impact you. So moving on to collective consultation and redundancy now, and recapping on the current rules. The current law on collective consultation in redundancies is that any employer proposing to dismiss 20+ staff at one establishment within 90 days must go through a process of collective consultation with elected representatives of the affected staff. The failure to do this can result in a protective award of up to 90 days uncapped pay for each affected employee. The employer is also obliged to fill out an HR1 form to give advance notice to the government that these dismissals by redundancy could be taking place. And consultation must begin in good time, at least 30 days before the first dismissal in the case of less than 100 redundancies, and 45 days for more than 100. Now, the original bill was proposing to get rid of the one establishment test completely. So what would have happened is if the employer was proposing 20+ redundancies across multiple establishments or sites, then that would have triggered collective consultation across the whole business. But the latest version of the bill keeps the one establishment threshold, but adds another additional test. So if the employer proposes 20 plus redundancies at one establishment, the current threshold, that's going to trigger collective consultation, but also so will some other threshold test. We don't know what that is yet, but it will be counting proposed redundancies across the whole of the business. That will be the new threshold test, and we're waiting for the regulations to tell us what that is. There's currently no changes proposed to the consultation period. So as I just said, 30 days for under 100 employees, 100 dismissals, sorry, or 45 days for more than 100 will remain in place. The bill will also double the maximum protective award from 90 to 180 days. So that's very expensive if you get that wrong. There's also going to be an additional amendment which says that collective consultation won't have to be carried out with all employee representatives together or with a view to reaching the same agreement with all employee reps. So that may be a welcome relief to those bigger employers with multiple sites or establishments where it's harder to get everyone together at the same time to consult. So it's likely that because of this reform, more redundancies are going to trigger collective consultation, and this additional threshold test is likely to impact employers with more than one establishment or site, and that's going to smaller numbers of redundancies across those different establishments are likely to involve the collective consultation. But it won't change collective consultation in terms of those employees employed by different entities. So if you're in a group of companies with different employing entities, different employees employed by different companies, then that won't capture collective consultation. So you've got employees at site X and Z, for example, employed by different or separate companies, they won't be counted together. But if you are a multi-establishment employer, small numbers of redundancies at different local sites are likely to get caught. And you're going to have to look backwards and forwards when you're making redundancies. So you'll be looking, if you've got some redundancies early in the year, you may not cross the threshold into collective consultation, but you have a new batch of redundancies later on in the year that could tip you over into collective consultation. And you'd look to see how you would handle that. We hope that government guidance will provide clarification on that in due course. Also, if you are a larger employer, you may want to think about electing employee reps so you have that body in place, ready to go in the event that any collective consultation obligations are triggered. So now we're moving on to talk about the Fair Work Agency. So this is a new government enforcement body that the government are creating for specific employment rights. Amongst other powers, it's going to have new powers to enforce the failure to pay statutory payments to workers like holiday pay and sick pay. It also gives the government power to extend the Fair Work Agency's responsibility to cover other employment rights as well. So essentially, the bill is confirming a single set of powers to investigate and take action against businesses that don't comply with employment law legislation. And it's based on existing powers of enforcement that enforcement bodies have. And the Fair Work Agency will also have the power to inspect workplaces and ask for documents from employers that demonstrate their compliance with employment law legislation. The power to issue notice of underpayment to employers will specify the amount that is payable to each individual within 28 days. And they can issue a notice for underpayments going back up to 6 years. So that could also be quite a big penalty. The notice of underpayment must also impose a penalty of 200% of the sum due to the worker, capped at £20,000 per individual, payable directly to the government. Though this can be reduced, the penalty can be reduced in certain circumstances, including early payment of that penalty. Moving on to statutory sick pay. So the government has now had a response to its consultation on SSP. This is proposed to be a day one right under the Employment Rights Bill. So a day from day one right of sickness. So for example, the waiting period of 3 days is now being removed, and everyone will be entitled to receive that. All employees will be entitled to receive SSP. So there's a minimum earnings level in place at the moment, but what is proposed is that SSP is paid at 80% of that worker's normal weekly earnings, or the SSP rate, whichever is the lower. The SSP rate is currently £118.75 a week. And there will be an annual uprating process. So that rate goes up every year, usually in April, with the other upratings such as national minimum wage, statutory maternity pay, etc. So we would advise that you look at your contracts and your staff handbooks and any other documentation or sickness absence policy, because you may need to update these in due course when this comes in, to show that the 3-day waiting period has been removed, and for the rate as well. So finally, let's look at fire and rehire. As I'm sure you're already aware, fire and rehire refers to the process when you've consulted with staff to make a change in their terms and conditions of employment, and you can't get agreement to that. So you dismiss and you re-engage immediately on brand new terms. There was a code of practice that was brought in by the last government last July on fire and rehire, which aims to give guidance on handling disputes and disagreements when you're doing this sort of consultation. But this is now due a big shake-up, partly because, and I think notably because of the big P&O case that achieved notoriety in 2022. The bill doesn't strictly ban fire and rehire practices, but it would severely restrict them. So what the bill does is it makes it automatically unfair to dismiss an employee if they don't agree to a change. So if as an employee, they refuse to agree a change in terms and conditions, or like in the P&O case, for example, you fire your staff and then rehire new individuals on different terms, like less pay, that will be automatically unfair. And the employer is now going to have to show that they're effectively on the brink of financial disaster in order to justify these kind of dismissals. So it's quite a high bar. Businesses are going to have to show that they wouldn't be able to carry on their business unless they did that. And that's probably going to be quite hard to prove for most businesses who would usually use this kind of thing in certain circumstances. There's also going to be a doubling of the protective award from 90 to 188 days per affected employee. So again, very expensive. Higher penalties for getting it wrong. Also, there's going to be a 25% uplift for the failure to follow the code, and in compensation awarded by the tribunal for the failure to consult or for unfair dismissal. So you need to be mindful of that. The implications are expensive. For example, you might have a contractual bonus scheme that you might want to change or amend. That's the kind of thing that's going to get caught by this now. Or you may be making changes to your contractual sick pay scheme or your sickness absence policy, for example, like I've just talked about on the sick pay slide. Again, this would be caught by that. So it has potentially big implications. You may want to think about anything that you're looking to amend or change, doing that now as soon as possible before the bill comes in next year. I'm anticipating changes on questions on flexibility clauses in contracts of employment. So you may have a contractual change clause in your contract of employment that allows for unilateral changes. Just because you have that doesn't mean to say that it's easy to effect changes of this nature, particularly to the employee's detriment. So just be careful of using that. It's there's a lot of case law on this, and I would say that that's probably unlikely to work in most cases if you're wanting to make a unilateral change to that employee's contract. I think what this is going to mean is it's probably going to mean a little bit more creative consultation and incentivization when you're trying to get employees to agree to any change, cleverer ways to get agreement for those changes. So we will keep you updated as to further developments in the legislative landscape as time progresses. And I'm now going to hand over to my colleague, Leah, for a case law update.
Thank you, Lindsay. So I am going to be sharing with you today 7 cases. I am going to start with possibly the most controversial of the cases, highlighting sexual harassment. It's a great opportunity as well for me to mention the training that we are able to offer for companies in relation to sexual harassment, following the new legislation that came into force in October last year, meaning that employers now have a proactive duty to take reasonable steps to prevent sexual harassment from occurring in the workplace. So the first case that I'm going to look at is British Bung Manufacturing Company and another and Finn. Now, this is an Employment Appeal Tribunal decision, and it looked at whether commenting on a male colleague's baldness can amount to sexual harassment. Now, in this case, Mr. Finn claimed that he was subject to sexual harassment at work after his manager called him a bald expletive and threatened him with physical violence. The employer did give the manager a warning, but the manager went on to threaten Mr. Finn again. Mr. Finn was later dismissed for gross misconduct in a completely unrelated matter. As a result of his dismissal, he did bring claims against his employer for unfair dismissal, wrongful dismissal, and harassment relating to sex as a result of the baldness comment. So just focusing on the sexual harassment element of their claim, in order to be successful in a claim for sexual harassment, the conduct must be unwanted and it must violate a person's dignity and or create an intimidating, hostile, degrading, humiliating or offensive environment for them. And then the tribunal will consider how the person perceived the perpetrator's conduct, the circumstances, and whether it was reasonable for the conduct to have that perceived effect. Now, in this controversial decision, the tribunal held that Mr. Finn's, the comment about Mr. Finn's baldness was harassment relating to sex. They also said that it was unwelcome and uninvited, so it was unwanted. Now, the manager in this case had admitted that he had made the threat to Mr. Finn, and it was made in a threatening way in order to insult him. And so the tribunal used that to say that it was done with the purpose of creating an intimidating, hostile, degrading, humiliating or offensive environment for him. And the tribunal reasoned that because the comment in relation to baldness related to Mr. Finn's physical appearance that could be linked to his sex, it would also constitute harassment relating to sex. This case was appealed to the, as I said, to the Employment Appeal Tribunal, but they dismissed the appeal. They agreed with the tribunal and said that the comment about baldness was related to sex, as it was targeted at a characteristic predominantly associated with men. Now, the Employment Appeal Tribunal were very keen to get across in this case that a comment does not have to be of a sexual nature to be linked to sex, and so offensive comments that exploit characteristics that are more common in one sex than another can be deemed to be harassment. So this case is just a really timely reminder, especially in light of the new legislation, and to remind employers of their duty to create an environment that is safe and free from sexual harassment for their workers. The next case I'm going to look at is Eastern and the Department or Border Force. And this looks at honesty and in recruitment and application processes. Now, Mr. Easton applied for a job with the Border Force, and in the application section, he only listed his years of employment, and he concealed, quite conveniently, a 3-month period in which he had previously worked for the Home Office and was dismissed for gross misconduct. He didn't disclose the information during the interview, and after being hired and was working with the Home Office, they discovered his previous dismissal, carried out an investigation, and they concluded that he had deliberately withheld that relevant information, and they dismissed him for gross misconduct. Now, Mr. Easton did bring a claim for unfair dismissal, arguing that he was penalised for not providing details that hadn't been explicitly requested. Now, the first instance tribunal said that the dismissal was fair and a reasonable applicant would understand that the employment history section required full disclosure, including any gaps. This was appealed by Mr. Easton to the Employment Appeal Tribunal, and they also upheld the decision. And they agreed that the tribunal had properly assessed whether the employer could reasonably expect applicants to provide a transparent employment history, and agreed with the process. So just a couple of key takeaways of this case. When recruiting, I think it's really important that you're clearly communicating what is expected. If you want full disclosure, just state it from the outset, just so that there can be no criticism or allegations from applicants that they weren't aware what should be reasonably expected of them. And then also, quite importantly, if an employee does conceal some material information, it can be considered a breach of trust and amount to misconduct, but you must still follow a fair process. You must carry out a thorough investigation, and you must be seen to be applying your disciplinary sanctions consistently and being able to demonstrate that you're following a fair process and acting in a fair and consistent manner is obviously always important. So the third case that we're going to look at is Miss Corotzi and the University of Hertfordshire and Ms. Lucas. Ms. Lucas was Miss Corotzi's line manager. And this decision focuses on whether accent can be discrimination, and whether criticism of that accent can amount to discrimination. Now, in this case, Miss Corotzi is a Brazilian national of Jewish ethnic origin. She was employed by the University of Hertfordshire as a marketing, engagement and partnerships manager. And her probation period was extended twice before she resigned. So she resigned before the probation period was concluded. And after resigning, she brought claims against the University of Hertfordshire and her line manager, Ms. Lucas, for harassment relating to race. And I've set out one of the comments that Ms. Lucas had made to Ms. Corotzi there. And she had said to her in a performance management meeting, you have a very strong accent, and although your English language is very good, it can be difficult for you to be understood. And this is an issue when your role is one of communication, engagement and partnership. Now, the initial tribunal dismissed Miss Corotzi's claims and found that the comments that had been made by Ms. Lucas about Ms. Crotsy's accent were not motivated by race and were more to do with understanding and comprehensibility, and so could not amount to harassment. This was appealed to the Employment Appeal Tribunal, and the Employment Appeal Tribunal has disagreed with that decision and said that in a claim for harassment, there is no requirement for a mental element like there is in a direct discrimination claim. And so there may be circumstances in which harassment occurs where the protected characteristic did not motivate the harasser. So, as in this case, an accent may be an important part of a person's national or ethnic identity, and so comments about a person's accent could be related to race, and criticism of that accent could amount to harassment if they violate the claimant's dignity or create an intimidating, hostile, degrading, humiliating, or offensive environment, depending on the circumstances. So this case is going back to a fresh tribunal for consideration as to whether it was reasonable for the comments that were made by Ms. Lucas to have that effect on Ms. Crotsy. It will be interesting to see the decision in this matter. And I think it could have really big consequences for employers in how they deal with staff at recruitment, but also in relation to poor performance management issues. So this is definitely one to keep an eye out for. And then my next case is one that you may be aware of because it has attracted quite a lot of media attention. It's the case of Higgs and Farmers School. Ms. Higgs is a Christian. She was a secondary school counsellor, and she was dismissed following some Facebook posts that she made. These were largely reposts, and they criticised relationship education in primary schools. Now, Ms. Higgs' criticisms focused on transgender issues, and after her dismissal, she claimed that her dismissal was discriminatory on the grounds of her religious beliefs. Two beliefs, the first being the lack of belief that someone could change their biological sex, and the second being a belief that marriage is an institution between a man and a woman. So it's important to note on this one that the Facebook profile used by Ms. Higgs was actually in her maiden name and not in the name that she was working under. And also her profile was only viewable by friends and her connections. So the only way that the school was aware of these posts was because a parent had complained and had actually sent in screenshots of the posts that had been made by Ms. Higgs. Now, this case has gone all the way to the Court of Appeal, and the Court of Appeal has found in favour of the claimant, Ms. Higgs. And they've said that her beliefs, so that gender is binary, and also that same-sex marriage cannot be equated with marriage between a man and a woman, are beliefs that are protected by the Equality Act. Now, the school did try to justify her dismissal, saying that the posts were excessively expressed and they include insulting references to the promoters of gender fluidity and the LGBT crowd, which were liable to damage the school's reputation. So as I said, the school did try to justify that dismissal on the basis that she had expressively expressed her views, and that also the school was liable to the posts were liable to damage the school's reputation in the community, as one parent had already made a complaint and they may be seen by others. Now, the Court of Appeal have said that neither the language of the posts nor the risk of reputational damage was capable of justifying the claimant's dismissal, and she had not said anything at work or treated any pupils in a way that matched up with the posts that she had made. And they had also commented that it was highly unlikely that any readers of her posts would believe that she was speaking for or on behalf of the school. So I think some really key points to take away from this case is, if you are dismissing just because somebody has expressed a religious view or another protected belief, then it will be unlawful discrimination. However, if the dismissal is due to something objectionable in the way it was expressed and not just because of the belief itself, then it will be lawful if, and it is a big if, the employer can show that it was a proportionate response and it was objectively justified. So as I've said, in this case, the Court of Appeal said that dismissal was not a proportionate response. So I think we've seen a lot of cases at the moment, especially considering the recent ruling as to the definition of a woman. And with the increase of social media and how people use that to express their views, it is something we should be considering very carefully should investigations and disciplinary action be necessary. Next, sticking with the theme of education, actually, for the next couple of cases, we have got the case of Houston and Ofsted. And in this case, Mr. Houston was an experienced Ofsted inspector with a clean disciplinary record prior to this, and he was summarily dismissed for gross misconduct. So he was dismissed without notice and no payment in lieu of notice either, after touching a pupil's forehead and shoulder to remove rainwater. So just to be clear here, there was absolutely no allegations of harassment or any safeguarding issues at all. But Ofsted had said that touching of pupils was not permitted and found, therefore, that the touching of the pupil's forehead was gross misconduct and dismissed him. Now, in the first instance tribunal, Mr. Houston was unsuccessful in his unfair dismissal claim, and he has appealed this to the Employment Appeal Tribunal, and it has also gone to the Court of Appeal, and both the Employment Appeal Tribunal and the Court of Appeal agreed that it was unfair dismissal. Now, a crucial part of this claim fell on the fact that touching of pupils was not listed in the examples of gross misconduct that Ofsted had set out in their policies. And the Court of Appeal here have given some really useful clarification when applying the principles to conduct dismissals. And what they have said is examples of gross misconduct are generally listed in disciplinary policies. If something is not included in the list, this does not automatically mean that an employer cannot summarily dismiss for it. However, if the act is unlisted, it will be critical to the fairness of any dismissal to consider whether the employee could reasonably expect the employer to regard the act as serious misconduct, having regard to the nature of the act and the surrounding circumstances. Now, as I've said, in this case, touching of a pupil was not listed as an example of gross misconduct in the policies and procedures laid out by Ofsted. And the Employment Appeal Tribunal and the Court of Appeal have said that Mr. Houston could not reasonably have expected Ofsted to regard it as serious misconduct given the context that it was done in. So I think a really important takeaway here for employers is making sure that your disciplinary policies and procedures are clear, they're thorough, and they're specific and tailored to your business. If you have got things that you consider as gross misconduct, they should be set out in your policies. It's a really good way of setting out what's expected of your staff, and also can then keep you protected should you need to rely on it in the future. And then, as I said, another education case here. This is a first instance case, so it's only at the tribunal, but I did want to mention it because the damages in this case were £168,000, so not an insignificant sum. This is a case of J. Smith and Alpha Plus Group. This is about a teacher who suffered from anxiety and depression, and he was dismissed as a result of a poor attendance record and behaviour issues, including falling asleep at school, that was caused by his mental health. Now, he brought a claim after his dismissal for discrimination arising from a disability. And the tribunal held in his favour and said that the school had acted disproportionately in dismissing him, as they had jumped straight to the dismissal, and that they hadn't followed their own capability, absence or disciplinary policies. Now, interestingly, in this one, the tribunal had noted that the school had actually acted reasonably sympathetically towards the teacher, and there was quite a lot of supportive WhatsApp messages to him from the deputy head. And also they had made some reasonable adjustments, such as allowing him to notify them at 8 AM that he couldn't come into work rather than 7:30, as was stated in the policy. What the employer was criticised for was a lot of these acts were done informally and they weren't done with a paper trail or any written decision-making process. So this really highlights the importance of keeping an adequate paper trail and of your decisions and demonstrating how you are complying with your own policies and procedures. Having policies and procedures is great and a must for businesses, but you need to adhere to them, you need to follow them, and you need to be able to prove that you are following them, and take advice before dismissal to ensure that you are protected. And then finally, I come on to the case of DeBank Haycox and ADP RPO UK Limited, and this in this case the Court of Appeal have given some really useful clarification as to when redundancy consultations should take place. This makes it very clear that redundancy consultations, whether individual or collective, must take place at a formative stage when the employee can still influence the outcome of any decision. And also that the consultation must include details about the commercial rationale for making the redundancy. So as you'll see there, I've got 4 takeaways for employers when considering redundancies. Number 1, timing matters. Must start the consultation as early as possible when the proposal is still in the formative stages. And this means it must be done early enough that the employee's input can have a meaningful influence on the outcome, and so before any final decision has been made by the company. 2, the consultation discussion points. So although group consultation is not required where there are fewer than 20 proposed redundancies, the topics for consultation must include the commercial rationale for making the redundancies, any proposed selection criteria and scoring methodology to be used, and also what information will be carried out when, what information will be considered when carrying out that selection. Number 3, transparency in scoring and criteria. So the scoring should only be taking place after consultation has started and the employees have had the opportunity to comment on the selection criteria. And then number 4, having an effective appeals process. Now, it's not compulsory to offer an appeal. However, a well-conducted appeal can cure any procedural defects during the original consultation process. And so I would definitely advise offering an appeal, especially if you think that there may be any issues in the way the consultation or redundancy process was dealt with. Now, we understand that sometimes businesses need to restructure or make redundancies that are practical for your business. And so we always suggest taking advice early on, just so that you know the best way to approach this for you and your business. So I think we have got some time for the question.
Yeah. Okay, so we've got a couple of questions from listeners now. Starting off with a question from one of the delegates today. If we don't have a disciplinary policy, or it doesn't give any examples of gross misconduct, does that mean that we shouldn't be dismissing, or we can't dismiss for gross misconduct?
No, not necessarily. I think obviously it would be great if your disciplinary policy does list everything, but if it doesn't, and realistically it's never going to list absolutely everything, if it doesn't, I think what you need to focus on is whether it's reasonable for the person that has committed that conduct to expect that you would believe it to be gross misconduct. And you still need to be following that fair process, investigation and procedure, because ultimately that's what you're going to rely upon.
Yeah, ultimately it would be within the band of reasonable responses, wouldn't it, for an employer if it came in front of a judge in a tribunal. So you'd have to look at, is it reasonable in all the circumstances? Okay, we have another question about the school case on beliefs. The employee's personal Facebook posts were investigated. Is that acceptable? Are we allowed to look at employees' Facebook posts as part of an investigation?
Yes. So I think in this case, one of the parents had screenshotted the posts and sent them in. So they have to investigate them as part of the investigation. However, I think what's more important, sorry, is how you're dealing with them and the response to that. Is your response justifiable? In that case, what they were saying is they'd gone all the way to dismissal and that wasn't justifiable. So there was actually no criticism of them looking at the Facebook post. That was seen as fine. It was how they dealt with that and their sort of response. And they said that the response was not proportionate.
Okay. And then if we've got time, which I think we have, just one more question. It seems that employers could be facing a tough time in relation to sexual harassment claims and be held responsible for matters that we're not even aware have occurred. Is there anything we can do? Is there anything employers can do? What should they be doing?
Yes, I agree. It is, the burden is a lot tougher on employers. I think, as I said at the outset, the starting point has to be training, really robust training for all staff across the board. Obviously, that's something we can help with, maybe done in-house, but I think that has to be your starting point. Another thing I would consider is risk assessments, that can really highlight potential areas in your business where harassment could occur and what you can be doing, whether there are reasonable steps you can take to prevent that harassment. And then a good old sexual harassment policy, I would say, and making sure that is distributed and circulated to staff, kept up to date and regularly reviewed. I think with this, the key is going to be regular reviews. It's not something that you can just do, tick a box and put on the shelf. We're going to have to be proving as employers and as business owners that it is something we're taking seriously. It is something that we're continually reviewing.
Brilliant, thank you. Thank you so much to everyone who's joined us today. Please get in touch if you've got any questions about anything that you've heard today or anything else. And don't forget to fill in our survey, and hopefully we'll see you at the next webinar, if not before. Thank you.